What would
I'm just making sure.
well, why would you think it was so, sir? If I knew you were here and you filed an appearance, I certainly wouldn't have
Okay,
any extra
just making sure.
conversation. You don't have to. I've been doing this for 20 years, so I
I'm
know
aware.
what I'm doing.
Thank you.
Go ahead. Okay. Okay. That's fine, Counsel. So what do you want? Is she here? Is anybody here? Okay, you can ask Ms. Collins to assign a docket number to it. She has her copy of the deed as well.
No, she had it here.
So it wouldn't be on the next month's court docket, but you're asking that the matter be adjourned. Put on the call together. I don't have any objection to that as long as they don't have any objection to it. It's just that would you be able to assign a docket number?
I don't know what the docket number was.
Whatever it is, just respect it.
So if we could just figure out the last docket number, just assign a docket number to it today and add it to the call today. I don't have any objection to hearing it. I don't think it's having. You're welcome. Okay, fine.
It's Misha, right? Misha? No, like what? No, I don't have it.
We'll wait until let's finish. You can trust me. No, I'm talking about with the rest of the cases. I do hearings at the last. You can continue.
Okay.
Counsel, I know what I'm doing. I hear trials at the end of the call, and it'll wait.
Judge, I mean, no disrespect.
Well, you
Explain to my
have
client
not,
what's going on.
that's not how you behave here so far.
I'm sorry that that's your opinion,
That is certainly my
but I
opinion.
apologize to the court.
I appreciate it, thank you. Oh, Mr. Allen, Mr. Allen. She has a complaint, she's complaining with me. She doesn't see her tape.
So I can refer to that case. I don't have it. So yeah, what would that name be? I don't know. I don't have, I mean, I need a name, but then she said that the investigation's not here either.
He indicated it was on the call.
Maybe it's for, I just have two people that came today and they're for December. I don't know.
What's the
But it was
address?
that month.
What's the address?
What address did she give? 614 North 7th.
For Loudview?
Yes.
Maybe it was last month and then,
What was the date of the hearing?
I don't have it, it's not on the docket. So maybe the respondent didn't bother to come and after they got the order and filed an appeal.
Well, ma'am, it's not on the docket. The only thing I would advise you to do is to contact Officer Allen
Yeah.
to find out why it wasn't on the docket, or maybe he gave you the wrong date. Are you gonna still check on it, Sergeant?
Yes, I'll check on it.
Okay,
George.
He's still gonna check on it. So you want her to wait, the complaining witness for that complaint to wait?
Yes, I'll get right with him.
Okay, he'll check on it.
page. It isn't, if we look here at the bottom, look at the bottom, the first page. I think that's the address well, here it has a different address.
It's fine. You want to skip? Ask me that, I should step up or step outside. She doesn't know, so.
I don't know. But here it has another address.
We'll see. We'll see. But if you're gonna talk, don't yell for us, as I've been doing as well. But
This was back from July. I hadn't even read. Here they have this one, but here. I think that it's probably taken from probably what happened, I'm only guessing, he already came here. I would imagine that it was default and they never came and filed a motion with me.
oh, you don't remember this much.
No, not
Because
at
the
all.
only way it would be, because she said it was scheduled to be heard, July 11th. So either it would have been continued, or it would have been defaulted and filed a motion. Are you two together? Are you together? Go around this way. Go around
This way, this way.
I have no way to know, but.
And Alan is on vacation today, thank you.
I just want to make sure we have. That's not something you can do. It's not up to you. It's up to me whether or not there's a violation, and then up to me whether or not there would be a fine. That would be due or not. At this point, we're just trying to figure out what you're here for. And so,
More than likely, I would say that it was up in court in front of you on July 11th, and no one showed up, and it was in default, so what happens after the court? I sent a copy of the order signed by the judge finding the person in default. If they don't come to file, request a second court date.
but that's why I'm thinking that he did, because he specifically told her that it would be up to day on the.
No, and I
I did file a motion.
no. And I talked to Alex 3 times yesterday.
The only thing I can tell you is that, when is he scheduled back?
I don't know, when he's out of state. I mean, he just came yesterday just to tell me what the weather is here today.
So you don't know.
No.
So you might just want to, well, Officer Farley said he would check, we can wait to see it, but if it's a Alex case.
There's a mix, because that is not the same address. I wonder if there's another typo. Because it's noise, but this person paid it. So I paid it.
It could very well be that it's a 61406 versus 7.
Because if that would be
Do
it.
you have that file?
No, because they paid it, so I removed it from the court, for the docket. I actually, because what was it for? I do, I gave it to them. It has to be this one, because it's, yeah,
This is your ticket.
that's it. That's it, they
We're
paid
trying
it.
to see whether or not they have any complaining information on it.
That's it, it has to be that one, because that's Officer Allen. It's a totally different, the address that I was given. So by paying it, there's no reason to come to court when they pay it. They either pay it before court or come to dispute it before their hearing officer.
They paid the fine. They paid the fine. I was just trying to figure out why he said it was also July.
That part I have no idea. That's why I kept thinking, that's not the address, I don't have tower. That's the closest one to now, I see her name. She's a complaining witness.
It's $200 fine unless they got one, $100 fine.
The fine is, I only have now. Yeah.
No, I said we'll be doing.
I don't know, but for this one, he was.
This is the one, 614 North South. Oh,
Your name is on it as a complainant witness.
I don't know. That's the problem. I don't know.
Oh, no. His address is 614 North 7. But your address then is 614 North 6? But this is it. And it was paid. Yeah.
Officer Fuller, do you still want to talk to him, or? Don't give her that.
No, this is mine. I want to give it to
Both of
him.
them were yours? The second? That was
Sergeant
yours?
Farley gave me this.
Oh, okay, I thought that was hers.
Yeah, this
So,
is.
this is it. This is your copy. He paid. So, okay.
What happened is,
It's in the office.
see what happened, he paid on the third, and he let me know the birthday was today, so he basically paid me my option. All right, so, all right. I'm sorry we didn't reach out before. Okay. All right.
Yeah, that's yours.
Okay.
That's your copy of the, paid, right?
Yes,
Yes,
ma'am.
you can, yes, yes. Counsel, you don't have to stand on these.
Okay, I just want to make sure.
Pre-trial.
Okay.
The case is the Village of Maywood versus George Johnson. The docket is PD 14212. Please step up, sir.
Mr. Rouse. Yeah, I'll hold it.
Mr. Ms. Collins, could you go tell them to step up? 1 second, sir. Could you go tell them to step up?
Our sergeant or our attorney? Ms. Harris?
Counsel,
Ms. Harris?
the attorney.
The attorney?
1 second. Counsel, step up, please.
Hi, my name is Rachel.
I'll be.
Step up.
Let me make sure. Okay, transparency, okay?
Okay, thank you.
Thank you. Any paperwork?
Sir? And again, the case is the Village of Maywood versus George Johnson, PD 14212. You don't stand with him, he's not representing you. There is a representative here on behalf of the village, sir, could you state your name?
Robert Forte Jr. on behalf of the Village of Maywood.
Sir, could you state your name? And the village has a motion? Sir, the village is making a motion to non-sue to dismiss the case. I'll grant the village's motion to non-sue. The matter is dismissed. She'll give you a copy of the order. You should keep it for your record.
Thank you.
Thank you. Thank you. Have it here, sir. Okay, what is your last name? C-O? Sir, I do not have your ticket. They did did not give it to me, so in order, I mean, I have to, it's not on the docket. I don't have it. So you need to find it and bring it, we'll be here till 1. I don't have it. I don't have it, they did not give it to me, sir.
Put it down.
Christopher Burr, is that you and are you Mr. Williams? Okay, tell me, like,
No, you don't. I make decisions. That's what I get paid to do.
I apologize for this.
You don't have to. I understand now.
I can't wait for the trial.
No, I understand now. We'll do it. We'll do it when it comes out.
My apologies again, Your Honor.
It's okay. I understand now.
Miller, Kionta, come with me, please.
Were they writing together?
Yes, ma'am?
No, I'm talking to counsel.
Separate.
Two separate cases,
Yes,
so we
ma'am.
can't consolidate.
I'm sorry, I cannot hear you.
My argument is the same issue, so.
I understand, but they're two different
If you
cases.
wish to
We'll
bifurcate,
see when the counsel comes out, if he has an
I
objection.
think once I'm done with my cross-examination, everything will be clear.
Well, I don't know if it'll go that far.
They're telling me that there is no retry in this case.
Well, it's not necessarily a pre-trial, but they still have to establish a prima facie case. Well, I guess that would include the cross.
That would include my opportunity to cross-examine
It would.
the chief, as unfortunate as it is.
It is. I agree.
But I've been forced to be put
This
this
is an
way.
ex parte communication, you know that, right?
I'm well aware.
But it is
Only
what
because
it
the
is.
chief has chosen to be in the other room.
It is what it is.
I'm more than welcome to have the same conversation with him.
And that's fine, we can do it on the
I will
record.
notify him of this conversation on the record.
We will. record. We're on the record, that's all.
He went somewhere? Okay, so we're gonna put it on the side?
Counsel.
Okay.
Go get counsel for me.
Absolutely.
His case, it should go before this one. I don't have it for it, it was never given to me. And Ms. Perry says it can be heard.
Brandy Winchell.
Here.
Hey, you grandma?
Certified permission to approach.
Yes, let's put it on counsel for the village.
You gonna take that off?
No, let's go ahead and just do it when you're ready. Sure. You ready? Now, council, should we consolidate these for the purposes of expediency? Because I believe the arguments are the same, even though they are different cases. Do you have any objection to that?
Judge, I have
Would
no
you have any
objection to
objection to it?
consolidation.
Okay. And the cases are the Village of Maywood versus SERJIO, last name CORDOVA. The docket is PD 14172, as well as Brandon Hawken, docket PD 14177. The respondent is represented by counsel. Counsel, could you state your name?
Richard Blatz, B as in boy, L-A-S-S, General Counsel for the Illinois Council of Police, on behalf of both respondents, Police Officer Hawkins and Officer Cordova.
There's also a representative here on behalf of the village. Sir, could you state your name?
Harvey Forte Jr. on behalf of Village Maywood.
Now, this matter was originally heard on October 3rd, 2014. It was continued until today on the respondent's motion for counsel. I believe the matter, there was motions filed on that date in which the village was served with, and then I made note in my order that the village to provide respondent's counsel with a response to their motion to dismiss at least 2 weeks prior to the next hearing date, or by October 17th, 2014.
Judge, respondents acknowledge kindly receipt of their reply to my motion.
Okay. Counsel, do you want to proceed with argument in support of your motion to dismiss?
Judge, I believe it's my motion. I have the burden, and yes, I'd like to call the witness.
And, let me just note by saying that this is an administrative hearing process.
Understood, Judge.
Technically, we don't have motions to dismiss,
I agree.
but I'm allowing both of you the opportunity to present your motions in the response and make arguments. Generally, because this is an administrative hearing process, the ordinance is that the village would go to, and whether or not, the issue is whether or not they've established a prima facie case. That's an indirect finding of whether or not the village has met their
The
burden, and
respondent
whether or not they
appreciates the
were.
opportunity, Judge.
But I still will allow, just for the record, I wanted to make it clear that we don't normally have a motion proceeding, but I've entertained the motions, so I'll let you argue. You can proceed, Counsel.
Judge, as a preliminary matter, for the purposes of the record only, in case this should proceed to administrative review, I ask if Your Honor has written permission from the State's Attorney's Office for counsel to proceed on these motions. I offer you what I would submit as respondents number one.
Written permission from the state's attorney's office to proceed on these?
Show me a copy of the counsel.
I'm not sure what you're arguing, Counsel, because I've already acknowledged the fact that I don't have any authority to rule on motions to dismiss directly.
That I understand, Judge. On this case, period, I've given counsel a copy of 625 ILCS 5/16-102, which states in pertinent part that the state's attorney of the county in which the violation occurs shall prosecute all violations, except when the violation occurs within the corporate limits of the municipality. The municipality may prosecute if written permission to do so is obtained by the state's attorney's office.
But we're not proceeding under the ILS, under the Illinois Vehicle Code. They're proceeding off an ordinance violation.
That occurred within the corporate limits?
Yes, at least that's my understanding.
I'm asking that this be allowed for the record and for those
For the
purposes
record,
only, Judge.
absolutely. And, well, not absolutely, but Counsel for the village, do you have any
May I
objection?
approach?
No, no.
And without any objection, I'll admit what's been marked as respondent.
Judge, I do so respectfully and for the sole
Well, let me
purpose
just,
of the
one
record.
second, Counsel. I'm just going to mark this as respondent. You just put it exhibit number 1.
That's
Do you
correct.
have any objection to me putting respondents on there?
I do not.
Okay, now make note that this is respondents. Exhibit number 1, and without any objection, I'll admit this into evidence as respondents, exhibit number 1. And is this, what section of the 625? This is the vehicle code?
That's correct. C as in Charles is the pertinent portion of that statute, Judge.
Right, but again, I'm not enforcing this section. I'm
Okay.
enforcing the village's municipal code. That's what they've been cited for violation, which says 77.09, and I do have the
It's not for
authority.
the purposes of argument, just to preserve the record.
I understand.
I ask legal, Your Honor, to call my first witness.
You can proceed.
Chief Talley?
Chief, you can step up and raise your right hand to be sworn. Do you solemnly swear or affirm, no, you should, well, I guess you can't say that, that's fine. You can stay there. Do you raise your right hand? Do you solemnly swear or affirm that the testimony that you provide will be true and correct?
Yes, ma'am.
And could you state your name?
Valdez Jolly Jr., Chief of Police, Maywood of Toledo, Illinois.
You can put your hand down. You can proceed.
May I? Thank you. Sir, could you state your name for the record?
Valdez Jolly Jr.,
What is your position with the Village of Maywood?
Chief of Police.
And how long have you been the chief?
11 months.
And prior to that, did you have any positions in law enforcement?
I did.
And what were those?
In 1983, I was a correctional deputy with Champaign County Sheriff's Office. 1985, I was an Illinois Conservation Police Officer with Illinois Department of Conservation. I acted current authority in the Department of Interior as a game warden. In 1986, I became member with Illinois State Police. I served on two task forces, one on anti-fraud with the FBI, review investigation, and then the second one with the Joint Terrorism Task Force. And then I retired out. I was retired for 4 years, became Chief of Police in Illinois.
I have respect for your credentials, sir. I must say that before I begin questioning you.
Thank you, sir.
Tell me what your highest level of education is.
I have a bachelor's degree, and I am 4 hours, I mean, 4 hour credit hours a week, certificate, and 20 hours a week from matriculating and homeland security.
Congratulations, sir. Did you attend the police academy?
I attended 3 police academies, yes, sir.
Can you tell me which of the 3 those were?
Yes, University of Illinois, Police Training Institute, and Illinois State Police Academy.
That's 2.
The 2 state positions, conservation and safety.
Have you attained any additional education as far as police staffing commands through Northwestern or the Southern Police Institute?
Yes, sir. I am a member and a graduate with distinction from the FBI National Academy Association with Guadalupe.
Congratulations. I have respect for that as well. Have you attended the police staffing command school through Northwestern?
No, I have not.
Or Southern Illinois University?
No, I'm not, but I have attended the University of Louisville.
Kentucky?
Yes.
Very good, sir. Are you members of any chief of police organizations such as the Illinois or National Association of Chiefs of Police?
I am.
Which ones are you a member of?
I am National Association of Chief of Police, Illinois Association of Chief of Police, International Association of Chief of Police.
Congratulations, I'm a member as well, and respectful of those memberships as well. That being said, sir, I call your attention to the municipal code for the Village of Maywood. Are you familiar with that code?
Yes, sir. Are you speaking specifically of 71.09?
Specifically speaking of the code in general,
Yes,
as it relates to traffic offenses.
Yes, I am.
You're familiar with it?
Yes, I am.
Have you had an opportunity in your tenure as the chief of police to discuss this code with your attorney? And by attorney, I mean the village attorney.
No, I did not.
But in your own understanding with your education and experience and tenure as the chief of police and having multiple years of experience in education and law enforcement, do you feel that you're familiar with the code?
Yes.
Do you take the oath of office seriously, that you uphold the laws?
Absolutely.
You take it very seriously as the chief of police, don't you?
I do, sir.
Are you aware of 7.01, which states in pertinent part that the Village of Maywood has adopted the Illinois Vehicle Code?
Yes, sir.
Are you familiar with that?
Yes, sir.
May I approach the witness, Judge?
You may.
And prior to doing that, I'd like to show my colleague a copy of 70.01 to make sure he doesn't have any.
70.01?
70.01.
No,
And Judge, if I may approach, I'd like to give Your Honor a copy as well.
And you have no objection, counsel?
No.
What did you mark this for?
Respondent's exhibit number 2, Judge.
And I'll have what's been marked as respondent's exhibit number 2 for identification.
Thank you,
To
Judge.
the record, you can proceed.
Have you seen this document before?
I have.
And can you tell me what it says?
Yes, it says Illinois Vehicle Code 625, Illinois Criminal Statutes 5/1-1,
petty offense, not a criminal offense, is that correct?
That is correct.
And can you tell me when that ordinance was enacted?
The ordinance
Yes, at the bottom
is
of it.
1997.
1997, okay, very good. So you're familiar and you agree that the Village of Maywood in 1997 adopted the Illinois Vehicle Code 625 ILCS as 5/1-100 et sec, which means the entire act in its entirety, is that correct?
That would be correct.
In 1997, correct?
That would be correct.
Thank you. Now I'm showing you what's marked as respondent's number 2. Showing it first to my colleague to make certain that there's no objection. I'm asking to approach Your Honor to provide you with a copy if my colleague has no objection.
You have any objection, Counsel?
Chief Talley, are you familiar with 7.09?
I am.
And you testified before that you have as you described it, a very good understanding of municipal ordinances, is that right? As they pertain to the Village of Maywood?
Yes.
In your tenure as a police officer and now chief of police, with all your experience and education, do you feel that you are well versed in the Illinois Vehicle Code as well?
Coming from the state police, absolutely.
Wear your hat and write a lot of bananas, right? A banana a day keeps the commander away? Fantastic. Can you tell me in that ordinance, anywhere in that ordinance, is there an exception for a police officer in an authorized emergency vehicle to not wear a seatbelt?
No, it is not.
And, thank you, it's nowhere in there. And, but just for the record, can you tell me when this ordinance was enacted?
This ordinance was passed in 1999.
1999, okay. Now, you're familiar, are you not, with a exception that was entered or brought as a bill by Senator Moffitt? Are you familiar with Representative Moffitt?
I don't know personally.
Are you familiar with the legislation that he supported or sponsored?
In 2010, I am aware of it.
Are you understanding of the additional exceptions that he supported or sponsored in 2013?
I'm aware of the language.
I'm going to show you what I have marked as response exhibit number 4. Again, I'm going to show my colleague to make certain he has no objection before I ask leave of court to approach the bench to give a copy to Your Honor.
No,
Sorry, this is the full copy. May I approach, Judge?
You may.
This is going to be, I'm asking leave to enter this as exhibit number 4.
Do you have any objection, Counsel?
No.
Without any objection, I'll have this submitted as respondent's exhibit.
And ask if you could look over your counsel's shoulder at what I've shown as House Bill. Can you tell me what House Bill that is, sir?
Sure. Yes, it's House Bill 2776.
Is there an underlined portion in that?
Yes, it was.
And what is the underlined portion? Can you read it to the court, please?
Yes, it's number 10. It says a driver or passenger in an authorized emergency vehicle, except this exception does not apply to vehicles of fire department, vehicles of the office of state fire marshal, or ambulance, unless the delivery of life-saving measures prohibit the use of a safety belt.
As you understand it, Senator Moffitt sponsored a bill and in fact accepted the bill that he passed in 2010, which accepted public safety officers, both police and fire, for wearing safety belts when they're in an authorized emergency vehicle. Is that right?
That's correct.
And in 2013, the House bill that you saw that was signed by the governor in August of 2013 became law, which made it specific to police officers. When they're in an authorized emergency vehicle and their passengers need not wear a seatbelt, specifically accepted. Do you agree with that premise? Fire department, on the other hand, not so much, which is why that House bill was passed in 2013. Is that correct?
That is correct.
So police officers have an absolute exception, not firefighters. Is that right?
Under that statute, under the Illinois Vehicle Code, yes, sir.
Correct. Not as far as you're concerned under the municipal code of the Village of Maywood, is that right?
That is correct.
Now, you're familiar as a chief with why that exception was made, both in 2010 and then clarified in 2013 specifically for police officers. In fact, you were the subject of an article in the local newspaper when you ticketed two of the officers who were on duty in an authorized emergency vehicle for not wearing their seatbelt. Is that
I
correct?
would object to the relevance of the question or its.
It's merely stating a fact, Judge.
Where are you going? What was the question again?
My question was, if he was a subject of a newspaper article that he commented in, which would be considered what he says to be.
You can answer it.
Thank you.
Yes.
All right, and in that article, now, you didn't personally write the citation, did you?
No, sir.
As the chief of police, you ordered a subordinate officer to cite them.
That is correct.
Who did you order to cite them?
The officer that I saw, which was Officer Sergio Cordova, I had ordered his sergeant, which would have been Sergeant Cordova. In terms of Officer Hawkins, the deputy chief actually saw that offense, and I was glad that I can't speak for him.
Object to what you thought, just tell me what you know.
He assigned a sergeant to write that particular one.
So, two officers, which you would agree were in uniform, on duty, and in an authorized emergency vehicle, is that correct?
That is correct.
And you cited them under the village code.
That is correct.
I'm going to show you what I'm marking as respondents number 5. I'm going to show it to your counsel to make certain he has no objection, and I'm asking legal court to approach the judge.
I would bring my objection to the relevance of an article.
The relevancy judge is whatever you say in public is fair game at a trial. He's speaking as the chief of police, as a representative of the Village of Maywood, and he was quoted in this particular article. I'm not entering this as hearsay. I'm asking him to testify to what was said.
I'll note your objection, but I'll admit what's been marked as Respondent's Exhibit number 5 into evidence as Respondent's Exhibit number 5.
Thank you. Chief Talley,
Yes.
did you say to the newspaper or to any committee in the village that in 2010 the legislature saw it fit to exempt police from wearing seatbelts?
I was at a, yes, 2 weeks ago, I was at a village board meeting. I was arguing for improvements and corrections to technical issues on the ordinance, and yes, I did make that comment.
Chief Talley, did you say, I don't agree with that?
That is exactly right.
When you took an oath of office as a police officer, was it to enforce the laws that you agree with, or to enforce all laws as they were written?
Objection.
Sustained. Ask your next question.
Chief Talley, did you suggest to the newspaper or to any village official that Maywood's municipal code needed to be updated?
Yes.
In fact, to be amended to include that the exception that was allowed for in the state statute under the vehicle code would not be accepted in the municipal code?
Objection as to relevance of the citations that were issued under the code.
Counsel, where is this line of questioning going?
You know where it's going, Judge? I'll tell you.
Well, let
And
me,
I'd argue against the speaking objection.
okay, because my question is that whether or not he agree or disagree on how his position it is, what I'm deciding is whether or not there was an ordinance violation.
Okay,
Specifically.
okay.
What the ordinance says, what happened, why the citation was issued. That is the limit of my authority. I've given you as much leeway as I
Okay.
possibly can to give you an opportunity to make a record.
I'll lay
I
off
need
that.
to bring you back, and the issue in front of me is whether or not it was an ordinance
I'm back.
violation. It's that simple.
Thank you. I appreciate that, Judge. Did you say that police need flexibility to quickly jump out of their cars? Did you say that police need to quickly be able to exit their cars to draw their weapons?
No, I didn't say that.
Are you familiar with any chief of police studies, as you stated in this article, that the reason for the exemption is to allow police officers to quickly exit their vehicles? Are you familiar with those studies?
When you ask me questions, I am familiar with several studies like you presented, the Illinois, International Association of Chiefs of Police. One of the studies that they made, shows the difference between officers who are killed in line of duty, and the study that they had during the same period of time was the 72 officers were killed by alighting from the vehicle from a failure to wear a seatbelt. I want all my officers to be safe, and that is why I uphold the ordinance of the village.
Let's go back to what you said. The study was from 1980 to 2008, not 2010, is that correct? If you need to look at the article to refresh your recollection, please do so. It's on page 4 of 7. Your attorney's got the article.
Well, the author of the article wrote what the author of the article wrote. I know what I said.
All right, so-
You can collect that from the tape records from the village.
But the study is from 1980 to 2008, right?
And I would object to any further questions.
Judge, I will,
If
I
I
will
could finish my
fix
objection.
this.
Let him finish his objection, counsel.
And based on the chief's previous response to counsel's last question, I object to any further questions on the statement, or excuse me, on the studies. The chief has testified as to what he said, and I believe counsel said anything that the chief says in a public forum is subject to this administrative hearing. I don't believe that there's any relevance to the studies or the accuracy of the studies at this point.
Judge, may I find the relevance with one more question?
What was your, you have no response to that, or are you just
My
gonna move on?
response is that it is relevant. I need one more question to tie it up, and I'm asking the court leave some little bit of leeway to tie this
Well,
up.
I've given you a lot of
One more.
leeway, counsel.
That's all I
I've
ask.
given you a lot. Again, I understand that you're trying to make a record, and I'm giving you that room to do that.
Thank you.
In the event that there's an administrative review
Sure.
of this entire case, and
Sure.
I'm giving you that. But I'll give you one more question, and
Thank
then
you.
we need to move on, okay?
Your statute, the municipal code, was enacted in 1997, is that right?
That's correct.
And 1999 for the seatbelt statute.
That's correct, sir.
This statute, the state statute with the exemption was enacted in 2010 and 13, is that right?
That's correct, sir.
So the study doesn't discuss any revelations from the pertinent time period which we're talking about right now, isn't that true?
Objection relevant.
Suspended.
Thank you.
Anything
I ask that
further?
exhibit number 5 be entered into evidence with your honor, and I'm asking permission to approach.
Maintain the same objection.
I'll note your objection, however, I'll admit what's been marked as petitioner's exhibit number 5, for identification into evidence, petitioner's exhibit number 5.
And just, please respond.
I'm sorry, respondent's exhibit number 5, thank you, counsel. As respondent's exhibit number 5. Anything further, Chief?
Yes, please, may I proceed?
You can proceed.
You were kind enough to hand me an ordinance that was enacted November 5th of 2014, is that right?
Objection relevant.
It's a seatbelt ordinance, Judge, I don't know how much more relevant it could be.
The officers were cited under an ordinance previously in effect. Any ordinance that was later amended or included in the village code has no
Overruled.
relevance.
Yes, exactly.
Overruled.
Exactly.
Answer.
Thank you, counsel, for that judicial admission. So in 2014, November 5th, after you cited my officers, and I apologize, your officers, my members, for driving without a seatbelt, you decided to petition the board, and they concurred with you, and you put an exception into the municipal code that says the exception under your home rule powers of the state law does not apply to your policemen, correct?
Objection, again, is to the relevance of any proceedings after the citations were issued and as to the form or language included in the village code, municipal code, at the time these officers were cited.
May I respond to that objection?
No, overruled, you can answer.
Thank you.
It was a technical error that I learned, and yes, I did petition the village to make the correction.
After the fact.
It was hard.
So you agree that at the time the village ordinance was enacted, both when they adopted the vehicle code in 1997 and again adopted the seatbelt ordinance in 1999, the exception in the law hadn't even occurred yet. Is that right?
That is correct.
And you seek on November 5th to correct that error.
Objection.
Sustained. Move on.
Judge, do you have a copy of the ordinance that was enacted on November 5th?
No.
May I approach?
And I would object to any submission of a new ordinance, which is not relevant or in the
Judge, it's
scope of
relevant.
your
I'm allowing
review.
him to make his record.
I'm happy to explain.
Ultimately, I'm gonna make a determination as to whether or not there was an ordinance
Is
violation.
that number 5 or 6?
It's number 5.
If we
6, rather, I'm sorry.
6, thank you.
The only thing I'm deciding is whether or not there was an ordinance violation, but again, I give counsel as much leeway as I can. We need to move on, counsel, for you to make your record
I'm done, but I'm ready for argument.
Administrative review, but we need to move on.
Judge, and I appreciate the deference the court has given me to allow me to make my record.
You can proceed.
I'm done, Judge.
Do you have any questions of Chief, Counsel for the Village?
One, Chief, actually, I will have no questions for the chief this time. I'll reserve the argument.
Okay, you can have a seat. Chief. Okay, any further argument with regard to?
I have argument, Judge, and case law I wish to present to the court.
Okay. Okay,
Thank you, Your Honor. May I proceed, Judge?
you can proceed.
You know, I am very respectful of the Illinois Constitution when they enacted the home rule in the Constitution, which allows municipalities to conduct their affairs narrowly related to their affairs. That's the catch statement here. The case that I brought to you may seem like it's not on point because it involves a construction company, but it speaks to the heart and soul of home rule powers. I stand here before you not as an attorney, but unfortunately as a retired police officer. I'm sure you're expecting me to make the thin blue line argument that cops don't write cops. Chief Talley testified that he is very concerned about police safety. I had the unfortunate circumstance of answering the call of a police-involved shooting where an officer stepped out of his vehicle and was met with the barrel of a handgun, and he could have lost his life. I'm not sure if he was wearing a seatbelt at the time, but if he wasn't, he was able to get out very easily. If he was and he wasn't expecting to get clipped, I would hope to God that the seatbelt would never get caught on his gun. I would hate to have to make that acknowledgement to his wife and children as he stood next to me shaking, saying, "That's not what I expected to happen when he pulled the gun on me." Fortunately, those two officers are alive today, and I can't say whether or not it's because of their seatbelt. But the two officers that I represent here today as an attorney, I've backed up every day for 20 years in the village of Bellwood. I'm mindful of exceptions in the statute, as was Mr. Moffitt, who is an Illinois state representative that holds dear to him his beliefs in public safety and their ability to enforce the law and take care of those people that have the audacity to pull a gun on a police officer so they don't do the same thing to any one of the residents in this room standing here today. I don't ask for any exception because you're a cop. I don't ask a police officer to show his badge to get a dozen donuts or to get out of a traffic ticket. But I expect that there be respect for the law that you're sworn to uphold. The forefathers and the founding fathers of the village of Maywood had no idea that police officers were going to take it upon themselves and go to the legislature and beg for an exception that allowed them to do their jobs. In 1997, the village of Maywood saw fit to adopt the vehicle code in its entirety. Of course they didn't ban the exception on cops because it wasn't there. Chief Talley testified quite credibly that in 2010 is when that exception came. In 2013, Mr. Moffitt saw fit that we didn't understand the exception enough, so they said, police officers, because we want to keep them safe, are accepted from wearing their seatbelt when they're on duty in a patrol car, in an authorized emergency vehicle, which Chief Talley testified that both Officer Hawkins and Officer Cordova were. So you see, if the forefathers want to exercise their home rule powers, it has to be with the knowledge that they have at that time. Both in 1997 when they adopted the vehicle code, and in 1999 when they adopted the seatbelt ordinance. 9 years before my beloved senator decided to enact the exception, and again in 2013. So I'm respectful and I'm mindful of counsel's argument, and it's a great argument. Home rule, broad powers. Kind of like administrative review. We're not going to second guess. But if they didn't have the opportunity to know what they were accepting at the time, it doesn't apply. And we don't have ex post facto laws in the United States, as far as I'm concerned. And certainly the home rule powers don't allow ex post facto law here today against two of my men. I apologize, Chief. Your men, my members, to enforce the law that they were sworn to protect. I'm going to bite my tongue and I'm going to be respectful because I respect the Chief's title. I want to be able to respect the Chief. I stand here with the veterans of law enforcement. Rich Bruno is a member of our union, smarter than I am. My counsel, Julie Trevarthen, came here to argue this, and I pulled rank on her. She's not a police officer. I'm not here to self-aggrandize. I've taken time out of my day not to only argue what the law is, and couldn't possibly be when this ordinance was enacted. But I'm here to argue so that these two fine officers that put their life in jeopardy for the village, for the chief, and for the citizens that sit here today, I'm not asking. I'm begging you that you have respect for the good senator and that you understand we can't go back in time and say we knew this exception was going to be there. I will accept the exception as it stands here as of November 5th of 2014, and I hope that it never stops these two officers or any of my officers from stepping out of their squad car to protect somebody. I argue with a tear in my eye today as to what this has become, what I'm forced into. I apologize to the chief of police for having to put him on the stand, but I had no other choice. I apologize to your honor for having to make a very difficult decision, but I know from appearing before you before, you'll make your decision on the law and on the ordinance and what's possible. And I apologize to my colleague who is learned, understands the law, and unfortunately is in this unfortunate predicament. Regardless, officers, how this turns out today, I'm standing in front of you, not behind you. I hope you understand. Village,
Counsel,
I'm standing in front of you, not behind
counsel,
you.
we need to move on.
I'm done.
Okay, go ahead.
Mayor, we would agree that this is a very limited scope. It's a very simple argument. It's not as complex as council makes it seem. It's a home rule that will be crushed. The village has laid out in its response that the village may concurrently exercise control over the use of seatbelts in the village of Maywood. Yes, there was an ordinance change passed this week. However, under the previous ordinance that was in effect at the time that these two respondents were cited, there was no specific exception for the drivers of authorized emergency vehicles not to wear their seatbelts. That laid out in these individuals must wear their seatbelts. Therefore, it's the village's position that because they're not exempted, they are covered under the plain language of the ordinance that says each driver and passenger of a motor vehicle operated on a street or highway in the state shall wear properly, in the village shall wear properly adjusted and fastened seatbelts. It's clear language that no one is exempted from this provision, which is a municipal code provision. The courts have held that unless there is specific authority within the Illinois Vehicle Code section to give the state exclusive control over enforcing a violation for such an offense, that the home rule municipality can maintain and enforce an ordinance that is contradictory to the Illinois Vehicle Code. The case that we cited is clearly on point. It's related to seatbelt use. It's related to a provision in the IVC that was in place back when the decision was made, and the court left no leeway. In addition to the village's position, we believe that it is a safety concern. As council mentioned, it's a safety concern that, as the chief testified, a large number of officers are injured because of not wearing safety belts. And that's the reason why the village's ordinance did not contain an exception for authorized emergency vehicle drivers or passengers. We don't believe it's a very difficult decision. We believe that the case law is very clear. The village's authority is very
So, we're going to
Village's
go?
case, I'm ready.
Let's go.
And if I could borrow a citation.
Are we, let's do Mr. Hawkins' case first.
Okay, check it.
I don't think it really matters.
I'm going to get the deputy chief right here.
Would you mind if we record over first?
Not
Because
at all.
the chief's tickets.
That's fine. Council, you made, the 5 exhibits. I am going to have them copy them so that they can be in both files.
Thank you, Joe.
Okay? Do you mind having me make a copy of them? Just one copy so I can have them put in both files.
Judge, can I have a moment
Here's
to
another.
drink water?
Absolutely.
Thank you.
Oh, Ms. Collins,
Yes, ma'am.
did you make a copy of this? Council,
Yes.
did he mark this as a response exhibit? I don't see a response exhibit number on it.
He did not. I believe he just provided.
Council, for the sake of the record, this case that you provided, I am going to have marked as response exhibit number 7, I believe.
7, thank you, Judge.
And does the city or the village have any objection to it being included?
Oh, no.
And without any objection, I'll have that admitted as response exhibit. You have that? One copy of everything. I just want to make sure that a copy is in the file.
Judge, I don't have the ability to put this on a record. They have permission to sit, not a lot of disrespect to the child being able to write.
No, that's fine. The village has
Bill, do you have any objection?
Sorry?
Is it okay if I sit? Sure. Thank you.
We're doing Mr. Cordova first?
Yes.
You can proceed.
And was the chief sworn?
He was previously
Okay.
sworn in, Council, Chief, I want to remind you, you are still under oath. You can proceed.
Albert Jolly Jr.,
And what is your current employment?
chief of police, village of Maywood, Illinois.
Chief, can I direct your attention to September 9th of 2014? Were you at approximately 3:30 p.m. working and on duty for the village of Maywood?
I was.
Are you in fact on duty at all times for the village of Maywood?
Unfortunately, yes.
I'm gonna let the mayor know.
Proceed.
Awesome. Actually, Your Honor, if I could take a look at this again.
This is Cordova.
At approximately 3:30 p.m., do you recall your approximate location?
Yes, I was traveling eastbound on Madison Avenue toward Madison with Deputy Chief Lightfoot.
And you were inside of a Maywood police vehicle?
I was.
Were you driving?
No,
Judge, your role is?
Overruled. You can answer.
Deputy Chief Wills was driving.
At approximately 3:30, did you observe another Maywood police vehicle?
I did.
And where approximately did you observe that vehicle?
It was inside the environment of the gas station that sits on First Avenue in Madison.
Could you describe what kind of vehicle it was?
It was a police cruiser Ford.
Crown Victoria? And was it marked with Maywood police logos and
you gonna be testifying? Are you gonna be calling him as a witness, counsel?
I don't believe so on this matter.
So you're not gonna be
I'm not
calling
sure
him?
which officer.
But there are two
There's
cases.
a deputy chief in the room, Judge, that I know.
Well, let me find, I understand what you're asking.
Thank you, Judge.
There are two cases.
Right.
Are you going to be calling any of these officers on either of the
I should
cases?
have Deputy Wills, excuse me, Deputy Chief
I'm
Wills.
going to grant the council's motion to exclude Officer Willis. You can start out.
The PO sitting in the audience is not part of this case, counsel?
I believe so.
You're not gonna ask, you're not
You have
gonna
a
talk?
token.
Yes.
No.
Thank you, Your Honor.
You can continue.
Officer Eckhart, excuse me, Chief, I know you told the court what you said to Chief Wills, but could you tell the court what you observed?
I observed Officer Cordova in the gas station. His assignment probably was to,
Objection, speculation, what it probably was.
Sustained.
Thank you, Judge.
Just tell the court what you observed.
I observed Officer Cordova get into his vehicle at the gas station. I observed him drive onto a highway without activating a seatbelt.
And what is the state highway that you're indicating?
It was Madison Avenue.
At any time during the period that you observed the respondent inside of his vehicle moving, did you observe he placed a safety belt on his person?
No.
Officer, does the village of Maywood maintain a policy for the use of seatbelts in authorized emergency vehicles?
It does.
Can you tell the court what that is?
In our rules and regulations, all officers are required to wear a seatbelt.
Objection, Judge. Relevance, this is for an ordinance violation, not for a violation of rules and regulations of the police department.
Overruled.
And is in fact that policy's been in effect since at least 2003?
2006, sir.
Excuse me, Chief. In fact, was the respondent then cited for municipal code violation 71.09, use of seatbelt in motor vehicle?
He was.
Was the respondent cited for an Illinois vehicle code violation outside of the...
Objection, relevance, and proper venue.
I'm sorry, let me finish the question and then I'll give you an answer. I didn't hear the question.
Was the respondent cited for any other, was the respondent cited for an Illinois vehicle code violation based on the actions that occurred on November 9th?
Objection, you have no jurisdiction.
Hold off before you respond on that. What's your objection,
No
counsel?
jurisdiction is within this administrative hearing office to hear a village ordinance. It's irrelevant.
Well, he's not asking whether or not I heard the case, he's just asking whether or not he was issued a citation.
There's no relevance to that, Judge. We're not here.
Well, that's a different in terms of relevancy, but
Correct.
I'll note your objection, but I'll open it, you could answer.
Thank you, Judge.
No, he was just issued an ordinance citation.
And could you describe for the board why it was your position to issue a warrant citation?
Objection, Judge. He did not issue the citation. His deputy-
Rephrase the question, suspect, rephrase the question.
Yes, sir. Could you explain for the court today why it was your position to have an ordinance citation issued for the action?
Yes, there are 3 reasons. First of all, it's a violation of policy. It's a fine-only offense as a second, and I didn't want to tie up our board and fire police commission with a suspension type hearing for insubordination for a fine-only offense. And it's for the second reason was public safety. And then the third reason is that I don't think that police officers should be exempt from the same laws that are required by the citizenry.
Chief, do you recall which officer or sergeant you required to issue the citation over time?
Objection, relevance.
I'm sorry, say that again, what's the question?
I just asked the chief if he knew which officer followed the order to issue the citation.
Which officer followed the order, which officer issued the citation? Is that the
Which
same?
officer? Yes.
Overruled, you can answer.
Thank you, Judge.
It was Sergeant Wayne Welch.
And did you give the sergeant specific authority to issue the citation?
I did.
I didn't hear that question. Did you?
Oh, did you give the officer, or excuse me, the sergeant authority or specific authority to issue the citation?
Okay. And your response was
I
yes?
did.
Nothing.
Cross, counsel?
Judge, may I approach to see the actual citation? Thank you. Chief Talley, you were aware that there's a state law that exempts police officers, right?
I was
And you admitted that you didn't agree with that statute, is that right?
correct.
And you admitted that the vehicle code needed to be changed because right now, or saying at the time that citation was admitted, or the time that citation was written, it didn't apply to this, which is why you asked for it to be amended, isn't that right?
I object to the relevance of this point. I believe these arguments are addressed in the motion.
And I'd object to him tapping his client to teach him how to respond to my questions.
Just indicated my client not to answer, so I.
And I understand,
Speculation.
counsel.
Okay.
I'll overrule the objection.
Let me answer your question, please, sir. You knew that the ordinance didn't apply to your officers, which is why you asked and said to the news that it needed to be amended. Correct?
We knew our objections.
You already objected. She already ruled on it. Can you answer the question?
It's a different
Okay,
question.
counsel, both of you, I'm gonna ask you, I'll give it one more time. Unfortunately, I don't have two counsels.
But I'm mindful of your authority. I apologize.
And I'm asking both of you to give each other the opportunity to ask the question. Let me respond to the objections and then proceed without interrupting one another.
I apologize. for
And
my
I've
comments
already
and your-
overruled the objection. Officer, Chief, you can't answer the question.
Okay, on the matter of, I knew that the law by statute changed in 2010. Yes, the ordinance remained in effect until it is changed or amended.
Correct. So it didn't apply to the officers at the time that your officers, my members, Hawkins and Cordova, the citation on that date. It didn't apply to them.
I would agree with that, sure. I have a
Well,
policy.
hold it. Is that a statement or is that a
It's a
question?
yes or a no question.
You didn't phrase it in the form of a question, it was more of a statement.
May I rephrase it?
Please.
Would you agree that at the time of the ordinance violation that you cited both of these officers for, it did not apply to them?
No.
But Jack can answer clear. I don't believe that's a proper question.
If he did it in the form of a double negative, but his question was no, he would not agree with that answer, that question. So I understood it.
Can you explain to the court why you took it upon yourself to request and have the ordinance amended if on its face in 1999 you felt it to be valid as it was written against Officer Cordova?
Objection to the relevance of the question.
Overruled, you can answer it.
Because after I had got your notice, then I covered it with the attorney to take the best course of action and what I needed to do to make sure that this type of matter would not exist in the future.
So would you agree that by your actions, not necessarily by your testimony, that you agree with the premise that at the time you wrote the citation, it didn't apply to the officers, which is why on November 5th, 2014, you took the affirmative action to change it to not exclude police officers?
No, I am not, no.
Nothing further, Judge.
Okay. Anything redirect? You can have a seat.
I would ask Judge, the citation is part of the record already.
It is. Well, I don't know, he hasn't admitted it yet, but are you seeking to admit this?
I'd say it's communication evidence on.
Well, no, are you seeking to submit the citation is what counsel's asking.
I am if you're not.
We can if it's counted.
That's the general process if you want
I'm
to
asking to make it a joint exhibit.
Well, no, I'll have it marked as the petitioner's exhibits or the village's exhibit number 1 for identification. And you have no objection to it being admitted, counsel?
No, Judge.
And without any objection, I'll admit what's been marked as petitioner's exhibit number 1 to evidence is petitioner's exhibit 1. You can proceed. Anything further?
I have nothing further.
Okay, and I've already moved on the motion to dismiss counsel. The village, or Mr. Cordova was charged with a violation of section 71.09
May I have argument, Judge?
for directed finding.
Yes.
You can, but that's what we did we addressed those issues on the motion to dismiss, and I denied those motions, so there's no need to readdress. That's what I was explaining to you, that the prima facie issue, case, and the procedure generally addresses the direct motions or the motions to dismiss. That's why there are.
Better safe than sorry. Thank you.
But, so we've already addressed that by me allowing you to argue the motions to dismiss, and I denied those motions. And so it would be my finding that the village has established a prima facie case with regard to the violation of section 71.09, and now is your opportunity to respond. You can proceed.
Judge, if you look at the exhibit,
Which is the exhibit
for
for the village?
Yes.
Okay, that's
citation, the signature by the chief of police who testified that he observed the violation. It's signed by a sergeant who never even saw the violation, which, as you know, procedurally is incorrect. On those grounds, I ask that my client be found not liable. But on further grounds, as I told you.
Counsel, let's stop. Are you proceeding to argument for closing, or are you gonna be proceeding, because right now it sounds like you're testifying. So unless you're gonna call a
I'm not
witness.
calling.
Oh, so you're not calling it?
You asked me if I wanted to close, I'm
No,
ready
no, no, oh, I didn't know, I said it was your opportunity to respond
to the argument, right?
to the village's prima facie case. So it was my finding that they've established a prima facie case, and now is your opportunity to respond with evidence.
I'm not
If you're
calling.
not going to call any witnesses, then we'll go directly to closing statements.
Thank you.
Counsel, closing?
We'll reserve for rebuttal.
Closing, you can proceed, counsel.
I don't need to repeat myself that the chief did not sign the citation, but more importantly, I agree with my client's argument about home rule powers. They're broad. They apply in this instance, and at the time the statute was enacted, that the village board knew about the exception. It's clear from my motion to dismiss that they did not, but don't believe me, Chief Talley advised that although he's only been the chief for 11 weeks, he knows that those statutes were enacted in 1997 and 1999 respectively. I point you to the Supreme Court case, Illinois Supreme Court case that I've given you, which says on the last page, and I quote, "When a local ordinance is silent to an issue addressed in the state statute, the local ordinance may not necessarily supersede the entire statute." So I've never agreed with municipalities hiding behind or using the home rule statute as a shield. In this case, they're using it as a sword to go after two law enforcement officers, and they're doing so illegally with a statute that they're sworn to protect and uphold the law. They have illegally written citations. And while I appreciate that Chief did not want to waste the time of the Board of Police and Fire Commissioners, respectfully, I believe we're wasting the time of this administrative hearing officer. The statute and the case law is clear. You can't sanction something that you don't know about. You can't, even under the home rule statutes, you can't say, if policemen's ever accepted from this in the next 100 years, or in this case 9 or 10 and 14 respectively, it's covered. That's ex post facto. That's bringing us back 1,000,000 years. You can't say, this is illegal now, so you're in trouble, which is what they're trying to do through your authority. So I say to you, I don't agree that this is a local problem. State legislature has addressed it. You can go on the internet and listen to the argument as to why this exception was passed. This is not an argument on locality. Every policeman faces these dangers every day in the state of Illinois, the United States, and the entire year, or the entire world. To say this is a local problem subject to home rule powers, completely disagree with. But that's a constitutional argument for the court, and I'm prepared to make it. For today, the home rule statute does not supersede the state statute, because nobody knew what they were contemplating when they enacted it. Chief Talley, by his actions, the board, by
Counsel,
their actions,
I
did
get
this.
it, let's move on.
Okay, I'm moving.
I have other people waiting, I understand your argument. Let's
Exactly,
move on.
I apologize for
I
wasting
understand your
everyone's time.
argument. You can proceed.
And the village maintains its position that our home rule authority allows us to enact and enforce contradictory municipal ordinance in light of the IDC exception for officers, or excuse me, not for officers, but for the drivers and passengers of authorized emergency vehicles. And that the facts of the case council do not address the specific instance in this matter before you. We believe that the village, or
time the Illinois Vehicle Code is amended or changed, it would have to be addressed in the village's ordinance. So generally, when you incorporate something by reference, you incorporate not only the ordinance, but any changes to that applicable portion that you've incorporated by reference. So when you incorporate the vehicle code, you're also basically, for the most part, and this is common practice in law, that when you incorporate something by reference, you specifically incorporate any changes that's also made to that section that you've incorporated to the village's ordinance. And that's what council is arguing, that by incorporating the vehicle code by reference, they don't know what changes are going to be made to the Illinois Vehicle Code. So when they make those particular changes, they're automatically incorporated by reference unless you specifically have something changed to your ordinance, specifically exempting that or prohibiting that. That's general practice in law, that, because again, just imagine how many changes are made to the Illinois Vehicle Code on a day-to-day, year-to-year basis. Are you then saying that they wouldn't be applicable under the village's ordinance if those changes were made unless there's something specifically in the ordinance, village ordinances, that addresses those changes or add those changes? Do you understand what I'm saying? And I think that's what counsel for I have a couple of problems with this issue. I mean, this case, it is a difficult case because I understand both sides of the argument. I understand with the chief, this is a policy. It's a policy that he's enacted, that he's requiring that his officers to enforce. I understand that. I didn't get it. I understand that he's also concerned about his officers' safety. That's why he's acting. So he's not doing it because he has nothing better to do, but because he's concerned about his officers' safety. I also understand counsels for the police officers' argument that, if it's something that obviously that the state legislator identified as being an issue for police officers in performing the line of their duty, where they made it such that they made a change to the Illinois Vehicle Code at the state level, then there's obviously and there's data and studies that support that change to the state statute, that it has to be something that's taken into consideration, whether or not the officers are safe and wearing the seatbelt. So it is a very, very difficult issue, but what bothers me the most is that generally speaking, anytime you incorporate something by reference, you're incorporating the changes that ultimately come to that section that you incorporated by reference, unless you otherwise specifically prohibit those changes in your ordinance. Now, I know it doesn't say that in your ordinance, it just says it's incorporated by reference, but once it made that change, you incorporated that by reference. You incorporated it by reference. So yeah, there is a village ordinance that says that everybody has to wear the seatbelt, but you incorporated that section of the Illinois Code, and when they made that amendment to the Illinois Code requiring the exempt police officers from doing it, you incorporated it by reference. So I'm not understanding why this is even here. To be honest. If you incorporate, yeah, you have a section of the ordinance that specifically says everybody has to wear seatbelts, but you've incorporated by reference the state statute that prohibits them from having to do it. Yeah, even though it was written at the time prior to that section being added, am I missing something?
Judge, I wish you could stand in for me to make my closing argument. You're doing a much better job.
I don't know if I'm
Thank you for
missing
understanding my
something.
point.
If I could just make a brief statement.
Yes.
For the record.
Yes.
We do agree that the village incorporated the IDC by reference
Yes.
back in 1997. We believe that was the village's position when the exceptions were included in the IDC, not to make those changes.
But it was incorporated by reference, so once you incorporate it by reference, you incorporated the changes that is made to the IDC unless you specifically do otherwise and says that, yeah, we incorporated it. However, these exemptions that have been changed, we're going to specifically prohibit these changes that's been made to the IDC. I don't see anything under section 71.01 that's excluding that exemption that was adopted in 2010. I don't see it.
I checked the notes, Judge. There's nothing in the.
So you've incorporated it by reference. Now, yeah, there is another section of the other Illinois vehicle of the states of the ordinance that says everybody has to wear a seatbelt, but when they're contradictory, I'd have to go with the Illinois Vehicle Code because you've incorporated it by reference as part of your ordinance.
The village's only position is that we agree with incorporated by reference, but that under our authority, we have the ability to maintain a contract
you do that? How do you say under one section it's incorporated by reference, they don't have to wear it, in another one, they gotta wear it?
They did it after the fact, Judge, on November 14th.
No, he's just saying by the section
Well,
of
I
the
know what
ordinance
he's
that he's citing,
Just a
that,
legal.
I know what you, that's not what he's saying. What he's saying is that by section 7109, it addresses that requirement for them to wear it. But in essence, then that's contradictory. And if that is in fact the case, that's your problem. That's your fault that it's contradictory. Because what happened is, what the chief has done is to take affirmative steps to make sure the ordinance is clear. Because they are now contradictory if we were just to look at them on itself right now. So I've listened to the evidence and the testimony, and it is my finding that based on the preponderance of the evidence, that more likely than not, the respondents are not liable. I'll give you a copy of the order.
Thank you, Judge. Is that to both officers?
We can go through the exercise again, but it would be
Judge,
the
I
same
adopt my
finding.
arguments for Officer Cordova, for Officer Hawkins. And I ask that you take those into consideration when making your decision on Officer Hawkins.
If I could just briefly confirm with my client.
You can, and obviously, the village has a right to appeal my decision.
Certainly, Judge. Thank you very much. Good, ma'am. You see this?
You can. I'm holding off, I'm holding this. Oh, I did hold this one. Did the wrong one. Which one is that? Oh, I did it. I'm right on the wrong one. But it's not making some decisions. So I'm holding it. Let's go to council.
Council,
Yes.
we have, we have a 10 o'clock hearing, and then you're 11, right, Mr. White?
Council,
And,
just want to, I'm sorry, Miss, 1 second. For this Brandon Hawkins, docket PD 14177, we can incorporate all of the arguments by reference, and then I can just make a ruling if you like, for the purposes of expediting the matter and to preserve your rights to appeal the decision.
And I completely agree that we should incorporate the arguments. I believe there was a previous ruling that there was a crime case, so.
I did. I found that there was a prima facie case on each of the matters. We'll incorporate the villages on, this is the case of the Village of Maywood versus Brandon Hawkins, Dr. PD 14177. The respondent is represented by counsel,
Yes, sir.
state your name.
Bishop Blasby Boyd, LASS.
There's also a representative here on behalf of the village, sir. Could you state your name?
Carmen Forte Jr.?
And I had denied the motion to dismiss. I found that the village established a prima facie case. We'll incorporate by reference the arguments made on behalf of the citation on the Brandon Hawkins case, as well as the arguments for counsel on behalf of Brandon Hawkins. And we'll incorporate all of the arguments by reference to the docket, the previous docket number. What docket number was that again, Ms. Collins? What docket?
Cordova?
Yes.
PD 14-172.
PD 14-172 is all of the arguments are incorporated by reference to docket PD 14177, and it would be my finding that based on the preponderance of the evidence, that the respondent is not liable for the citation. She'll give you a copy of the order in one moment.
Okay, I don't have the citation for Cordova.
Did you give her the citation back?
I need the
Yes, we put it back in the file. We entered it as evidence.
Right, I want to.
There's one right there. That's
Oh,
right.
it have that, maybe I did it to Hawkins.
I think it came.
Hawkins is here.
Okay.
Yeah, it's
Okay.
okay.
I got you. Got it.
Okay, so council, so we hearings, or we have the two?
Let's proceed. Let's get the people who've been here for a while out.
Okay.
Let's try some cases.
One moment, Judge.
Willie Brown, Fish Legal Community Service, please.
So you requested a non-suit? Yes. Oh, okay. Did we do an order for? Okay, okay, let's do that. That's fine. The case is the Village of Maywood versus Brady, Montana, Gabrielle, Brady, Montana. Docket PD 142. your right hand, please